Very good. Good morning. My name is Eric Holm. I'm the president of the State Board of Guide Dogs for the Blind. We have one speaker who will be here in about 5 to 10 minutes, but I thought we'd take care of some basic housekeeping before we get into the actual formal program. Let's see, there's a cafeteria cafe that's on this floor on the opposite side of the lobby if anybody needs anything to drink. The ladies' room is over on that far side of the lobby. The gentleman's room is on this side, just outside. If you would please shut off all your cell phones or set them on vibrate, that would be greatly appreciated. Antoinette, what else on the housekeeping do we need?
Mentioned the cafe and the restrooms?
Yes.
Okay, I think that was it, and we'll go ahead and do introductions around the room.
Okay, very good. Well, first of all, Antoinette Sark is my executive officer, the most wonderful executive officer there has ever been. She will be going around the room with the a microphone for the question and answer period after the speaker's statements. So again, let me just introduce our speakers that are here right now. Again, I'm Eric Holm. I'm the president of the State Board of Guide Dogs for the Blind. Next to me is Liz Savage, who is an attorney with the United States Department of Justice in the Civil Rights Division. And it's Stuart Seaborn, who is an attorney with the Disability Rights California. So you go around the room. And just if you'd give your name and who you're with.
Go ahead,
Joe Xavier, Department of Rehabilitation, Guide Dog Board Member.
Jeff Neidig, Guide Dog Board Member.
Okay. Frank Welty from the California Council of the Blind and Guide Dog Board Member.
Tom Scott, I'm Vice President of the Guide Dog Board.
John Hanley, California Independent Grocers Association.
Paul Mundell, Canine Companions for Independence.
Joy Van Kuren, Turning Point Community Programs.
Sonia Merrill, Office of Professional Examination Services.
Cynthia Marquez, Office of Professional Examination Services.
Roger Richter, California Hospital Association.
Lisa Bandakari, California Department of Social Services.
Larry Grable, Guide Dog Member.
Mark Mason, Division of Legislation.
Laurel Goddard, DCA Publications Design and Editing.
Linda Kapovich, I work for the Board of Pharmacy, but I'm here as a Disability Awareness Committee member.
Becky Tolbert, Office of Special Services.
Steve Stone, CHP.
Ed Bertola, CHP, representing the state capitol.
Michael Sullivan, I'm a retired San Francisco police sergeant. I was the ADA coordinator for 17 years.
Avis Walsh, Department of Consumer Affairs.
Okay, thank you.
Thank you very much. My guide dog Ford also asked. Okay, very good. Thank you very much. So the State Board of Guide Dogs for the Blind has been licensing trainers in schools in the state of California since 1948. We are the only such regulatory board in the United States, and as such, we get a tremendous amount of inquiries from law enforcement, private sector, public sector regarding the roles and responsibilities of guide dog teams, and also, as it turns out, being the only regulatory agency of our kind regarding service dogs in general, which is why we thought it would be a good idea to put together this program what is a service dog and why you need to know. In 1991, the United States Department of Justice started to revise the rules and regulations regarding service animals. The changes were signed by the Attorney General of the United States, Eric Holder, in September 15 of last year, and will go into effect on March 15 next month. We've assembled experts in the field who have taken part in both the regulatory change process and have a great deal of life experience with service animals. So I think, that being said, I'd like to turn the program over to our first speaker, who is Liz Savage from the United States Department of Justice.
Thank you, Eric. Good morning, everyone. Can you hear me? As Eric said, we at the Department of Justice enforce the Americans with Disabilities Act. Two sections of that law, one that covers state and local government entities, that's known as Title II of the law, and the other is Title III, which covers public accommodations and commercial facilities. Commercial facilities are things like office buildings, factories, manufacturing plants, areas where the public normally doesn't go, and where the issue of service animals really isn't very relevant because the public doesn't go there. But the most important area for all of you and for Title III entities are what are known as public accommodations. Any business, basically, that's open to the public, which can range from a private business, which can be a private hospital, grocery store, a hotel, a theater, any type of other store, a private daycare center, any type of museum or private park, an amusement park. There are 12 categories of public accommodations, and it's intended to be very broad. State and local governments, obviously, are any public entity. So if a hospital was a county hospital, that would be covered by Title II. The requirements that I'm going to talk about are identical for both types of entities, public and private, Title II and Title III. The original ADA regulations went into effect, as Eric mentioned, in 1991. And these regulations that I'm going to focus on are our revised regulations that he said were put in the Federal Register on September 15th of last year, and they take effect on March 15th, about 3 weeks from now. So what we do in our service animal provisions is we revise them somewhat, and then we clarify things that had been in our technical assistance guidance under the 1991 regulations. So a lot of what I'm going to talk about, if you're familiar with service animal provisions, is not very new. But there are some new things that I want to focus on. And first, the definition of a service animal is now limited to a dog. And secondly, that dog cannot be what is known as an emotional support dog or a dog that provides companionship or comfort. And third, our regulation clarifies that a service animal, the dog, can work for an individual who has either a physical, sensory, psychiatric, intellectual, or other mental disabilities. The precise definition in the regulation of a service animal is a dog that's been individually trained to do work or perform tasks for the benefit of an individual with a disability, whether that individual has a physical, sensory, psychiatric, intellectual, or other mental disability. Now, the key here is that the dog must be trained, and it can be trained through a school or a program or by the individual, him or herself, has to be trained to do work or perform tasks. And the regulation and its guidance provides illustrative examples of the types of tasks or work that can be done. The tasks or work that can be done must be directly related to the individual's disability. But the list that's provided is not an exhaustive list, it's just an illustrative list. So, for example, obviously, a guide dog that helps a blind person or a person with low vision navigate is an example. A dog that provides a person who is deaf, who alerts a person who is deaf or hard of hearing to sounds. A dog that alerts a person with epilepsy to an oncoming seizure. With respect to people with psychiatric disabilities, dogs can alert people, remind people to take their medication, or they can prevent or when a person is having an anxiety attack or they're involved in dangerous behavior, that the guide dog can prevent or interrupt that type of behavior. So that's, people with psychiatric disabilities have dogs that are trained to do that. People with PTSD, post-traumatic stress disorder, have dogs who are trained to do similar things. So it's a wide variety. People, kids, children with autism also have dogs that are trained to calm them down. So the key is that the dog has to be trained to do work or perform a task, and it has to be directly related to the individual's disability. If a dog just senses that an individual may be in harm's way or may be about to hurt themselves, but doesn't do anything about it, doesn't perform a task or do any work to help the individual, that's not a service dog. Okay. With respect to, everyone always asks, well, when can a service dog be excluded? And the answer is in two situations. One is the dog is out of control and the handler, the individual with a disability, can't take effective control to get the dog back into control. And the second is if the dog is not housebroken. And we often get questions, well, what if the dog has an accident? And our guidance that accompanies the regulation says the dogs must be trained to retain waste absent accident or illness. So an occasional accident is allowed. So again, dogs have to be in the handler's control and they have to be housebroken. If the dog is not, then the public accommodation or the state or local government can exclude the dog. However, if the dog is excluded, not allowed into the business or the public entity, facility, the individual with a disability must be allowed in without the dog. Failure to allow an individual with a disability into the facility without the dog would be a violation of the law. So what does it mean for the dog to be in the control, in the handler's control? Dogs must be either on a harness, a leash, or be tethered in some way. But if a harness, leash, or tether would interfere with the tasks they're performing or the work they're doing for the individual, or for some disability-related reason, they can't be harnessed, leashed, or tethered, then the individual can be allowed to maintain control by either their voice or signals or some other effective means. But the individual must be able to control the dog. And again, these are dogs that do work or perform tasks for the benefit of the individual with a disability. So providing mere companionship or emotional support or comfort is explicitly stated in the regulations as not being a task that's allowed. So those dogs are not permitted under the ADA. However, the Fair Housing Act and the Air Carrier Access Act, which covers airlines, the Fair Housing Act covers both multifamily and single-family dwellings, permits dogs as a comfort animals as a reasonable accommodation. So an individual with a disability who has a comfort or companionship animal, dog, can have the dog in their home or can take it on an airplane, but they wouldn't be, they'd be not be allowed to take it into a restaurant, a hotel, a theater, etc. With respect to other issues, dogs must be allowed into all areas where the public can go. We get questions about hospitals, and our regulations basically follow, and our guidance explicitly follows the Center for Disease Control guidance, which says that if an area of a healthcare facility or a hospital has limited access because of infection control, like an operating room or a burn unit, then a dog cannot be permitted to go into those areas. But any other area, such as a waiting room, an emergency room, a patient's room, the cafeteria, the hallways, those areas should be open to service animals, as long as they're within the control of the handler and that they're housebroken. In terms of permissible inquiries, what can you ask an individual about their dog? There are three issues. One, if it's apparent that the dog is a service animal, such as it's apparent that the individual is blind and they're using a guide dog, you can't ask them anything because it's obvious. Secondly, you can ask if the dog is required because of a disability. The dog is required because of a disability. And you can also ask what work or tasks the dog has been individually trained to perform on behalf of the individual. Other than that, you can't ask anything. You can't ask anything about the nature of the individual's disability. What type of disability do you have? You can't ask whether the dog has been certified by a training program or whether the dog has any type of license. Now, license specific to service animals. If all dogs in the state of California, and Stuart will talk about that, or in a county, are given a license verifying that they have been given rabies shot, for example, then obviously a service animal has to comply with those requirements. But there can be no specific requirement for service animals. And as I said, nothing into the nature of the disability unless it's a question about, is this dog required because of a disability, and what work or tasks has the dog been trained to perform? In terms of surcharges, let's say a hotel wants to charge an individual who has a service animal to bring in that animal to their guest room. That would be a violation. There are no surcharges unless the hotel has a policy that, or any other business for that matter, has a policy that any damage that's caused by the dog would be the responsibility of the owner or the handler. In that situation, if the service animal causes damage to the property of the business, then the handler, the individual with a disability, can be charged for the damage. And it's obvious that, but the regulation is explicit, that both state and local government entities and facilities and private businesses, public accommodations, are not responsible for the care of the dog. The individual who owns the dog, the handler, is. Lastly, I want to talk about a new provision. I said that the definition of service animal was limited to dogs, which is true. So before, there was no definition of service animal, and people were taking things to businesses. Antoinette told me she got a call from a store about a shopping mall about a boa constrictor. We've heard of parrots and pigs and things that are rather creative, but in the words of our guidance, had the potential of eroding the public trust. So that's why the definition of a service animal is limited to dogs. However, there's some people with disabilities who are allergic to dogs, and some, for that matter, can be severely allergic to dogs. And some of those individuals use miniature horses. Now, this is very, very limited. It's a very limited number of people who use them. And as you'll see from my description of the assessment that has to occur about what type of miniature horse can be allowed into a facility, it's much more limited than a service animal that is a dog. So a miniature horse is typically weighs between 70 and 100 pounds. And its height is typically between 24 and 34 inches measured to its shoulders. But the Miniature Horse Foundation says that they only use miniature horses that are no more than 26 inches. There are 4 assessment factors that have to be taken into consideration and by the business or the public entity. And if you feel, based on objective facts, that the horse does not meet any of these, then you're entitled to exclude the horse, the miniature horse. But once again, the individual without their miniature horse has to be allowed into the public facility or the business. So the first factor, there are several types of miniature horses, but they all average between 70 and 100 pounds, and around the ones that are most commonly used are around 26 inches high. So the first factor is the type, the size, and the weight of the horse, the miniature horse, and whether that type, size, and weight can be accommodated in the specific facility. Secondly, the miniature horse must be under the control of the handler, the individual with a disability, cannot get out of control, must be housebroken, and these miniature horses are trained to be housebroken. And lastly, and this is important, is whether the miniature horse's presence in the public facility, the government entity, or the private business would adversely affect legitimate safety standards. And those have to be based on fact, not on fear or stereotype. So those are the four factors that have to be taken into consideration in terms of whether horses, miniature horses, I should say, should be admitted. All of the other rules apply with respect to permissible inquiries. Is the miniature horse required because of a disability, and what tasks or work are they trained to perform? No questions about certification or licensure, or the nature of the individual's disability. No surcharges unless there's some damage that's done, and the business has a policy of charging everyone for such damage. So they're basically the same requirements that they should be allowed into all areas that any other type of dog was allowed into, subject to the four factors I just articulated. So it may be in a certain situation that the facility determines that doesn't meet safety standards to allow a miniature horse into a certain part of the facility. But that must, again, be based on legitimate safety standards and not myth, fear, or stereotype, that it may upset other customers or the public, et cetera. I can take questions when, in terms of what happens if an individual is excluded because of their service animal, and they answer the questions appropriately about whether the dog is necessary for a disability and what types of work or tasks the dog has been trained to perform, and a state or local government facility or program or a business, a public accommodation excludes them, that individual can file a complaint with us, and we have discretion on whether to take it. We evaluate all complaints very carefully. Sometimes complaints are referred to mediation. We have paid professional mediators that have been trained in the ADA, as long as both the individual with a disability and the business agrees to mediation. And sometimes we investigate, which is usually on the phone or through documentation. All of our settlements agreements are on our website, www.ada.gov. And you'll see that when we do a settlement with an entity, whether it be a state or local government entity or any type of business around failure to admit an individual who uses a service animal, we always require that that entity develop a comprehensive policy to admit service animals and do staff training. And staff training And ongoing staff training, especially at businesses where there's turnover of staff, is really essential to making this work. And failure to do staff training, for that matter, can result in unfortunate circumstances and an individual filing a complaint because they weren't treated appropriately. We have a course on our website for businesses, and the same actually applies to state and local governments. We have the right to get compensatory damages for individuals, and depending on the situation, it's appropriate. And in some situations, against public accommodations, the government has, the Justice Department has the authority to get civil penalties, which go to the United States Treasury. And civil penalties are really obtained in most situations where the entity hasn't dealt with us in good faith. We've had some entities who don't return our phone calls. It's not a good idea if you get a phone call or a letter from the Justice Department and don't respond. So we always try to work with entities in good faith and to be reasonable and work everything out through negotiation and technical assistance rather than litigation. We have a website that is being constantly updated, and it will have new information and documents on our new regulations that are will be put on the website on an ongoing basis over the next year. And there'll be a new service animal one up within the next couple of months. So if you should always check ada.gov and click on what's new, and it's always chronologically the most recent is at the top. And we encourage, or you can sign up for our to be notified. We have a massive email network where we notify people of new documents when they're placed on our website. We also have a toll-free information line for the public where we have experts, our staff, who are very well trained to answer questions, and they're supervised by lawyers. The number is 800-514-0301. And it's open East Coast time, so it's 9:30 to 5:30. Monday, Tuesday, Wednesday, and Friday, and then on Thursday morning on the East Coast they have staff meetings, so it's open 12:30 to 5:30. Whatever the standard time or daylight time is on the East Coast, that's what we follow. But so we encourage you, if you have any questions, to call our information line. So with that, I'll turn it over to Stuart and look forward to your questions.
I'm Stuart Seaborn. I'm an attorney with Disability Rights California. We're a statewide nonprofit disability rights organization. We receive funding from both the federal government and the state of California. With me is Fred Neeson, who's an attorney in our Oakland office, and both Fred and I work on disability rights issues in California. We've been actually asked to talk about state law issues. Liz has given an excellent description of the federal law surrounding service animals, and I wanted to point out that everything that Liz has said is valid in California. California generally tracks federal law, and for those of you who know a little bit about preemption, the ADA is the minimum or the floor of protection for disability rights in California, including with service animals. And so if you have a situation where you've got a state law that provides less protection, that portion of the state law is invalid. Fortunately, in California, there are no state laws that provide less protection for disability rights. And as Liz has mentioned, the ADA is pretty much protection for people who are bringing in service animals. The state of California does not, and actually this is pretty much explicit in the state law. the state of California does not explicitly contravene or we've found no situation where the state law provides less protection. One thing I wanted to bring up with state law is surcharges. In the state of California, a public entity or a private entity cannot charge a surcharge on a person with a disability using a service animal. However, the Civil Code at Section 54.2 allows a private business or public entity who's experienced some damage due to the service animal to charge that individual for damage. Of course, that entity would have to show that the damage was caused by the service animal. Another interesting piece of California law that is, and I'd like to mention, is parallel to federal law, but needs to be addressed, is the Food and Agriculture Code has a provision, and I'm sure that the folks at the Guide Dog Board are very familiar with this provision. It requires counties to endorse service animal tags and identification based on a certain set of criteria. I do want to point out that that portion of the Food and Agriculture Code does not allow the counties to violate the ADA. And so if somebody is in a public accommodation, a private business in California, and they do not have a tag or they haven't been endorsed by the county under that California Food and Agriculture Code, the public accommodation cannot require it. So it's something that we get calls from people in the public saying, what can I do to ensure that my service animal is protected, that when I walk into a restaurant, a barbershop, in any kind of public accommodation, I'm going to know right away that they're not going to be able to stop me from bringing that animal in there. One thing they can do is get their animal registered under this California Food and Agriculture Code, and most counties in California that we've talked to have pretty straightforward provisions. One thing that the person requesting the service animal and requesting the identification tag is going to have to state to the county is that they know it's a misdemeanor to fraudulently claim that they're using a service animal. And so it's a bit of an oath you have to take if you're seeking an identification tag. Many of our clients and folks that call us who are going through this process have gone through certified and trained guide dog schools, and the process is made much more streamlined for them since they are actually using certified guide dog trainers in schools. But I want to reiterate that the federal law is a floor or a minimum of protection for people using service animals in California. And because of that, the state law specifically says that you cannot require such an identification tag. We see it as a preemptive measure. Many of our clients, and we often get calls from people who have gone into private businesses. This happens, fast food joints, restaurants. We've gotten calls about beauty parlors, where it's a person that does not have an obvious physical disability. Usually, it's not a seeing eye dog. And the restaurant or business or whatever the public accommodation is will tell them, we don't think you have a guide dog. And in some cases, although it's illegal, they'll ask for identification. And so this is kind of a preemptive measure that the state has taken upon itself to say, look, we realize that it's not required, but to the extent people are getting discouraged from entering public accommodations and private businesses open to the public with their service animals, this is something they can use. One thing that Fred will talk about, and that's somewhat unique to California law, if you have a service animal that's in training by one of these entities, or by somebody who's licensed and certified to train service animals in California, that animal has to be admitted into a public accommodation in California. And you're probably asking, well, how do I know if the animal's in training? In that particular situation, the public accommodation or private business can ask for identification. If it's a person that's actually using the service animal because they have a disability, then the identification cannot be asked for. As Liz said, and this is true in both state and federal law, you can ask if the service animal is due to a disability. You can also ask what that animal is trained to do. Beyond that, though, that in California as well as with federal law, you can't ask for identification for the service animal. An additional point in California law that I'm somewhat less familiar with, I've only seen it put into play in one situation, but I think it's important for business owners and law enforcement to take into consideration, is the California Penal Code. And how many folks here are in law enforcement, if you could raise your hand? So you guys may know more about this in terms of enforcement than I do. But under the California Penal Code at section 365.5, if a public accommodation or private business is open to the public prevents somebody from using their service animal in that public accommodation, essentially from going to the same place as somebody without a legitimate service animal could go, that person could be guilty of a misdemeanor and a fine up to $2,500. Like I said, I've only heard of one situation where there's been an actual enforcement of this penal code provision, and it was just a warning. We had a client on another matter going to a beauty parlor, and that client had a service animal. Later, we found out from the client that the law enforcement was called when the service animal was denied entrance, and there was no fine issued, but there was a warning, and the public accommodation was required to admit the animal. So that's if you deny access to a service animal under the penal code. If a person is found to intentionally be denying access, so say the person knows it's a service animal and they're still keeping them out, and there's an intent piece to that statute. If you're found to essentially doing it on purpose, then in addition to the possibility of a fine, there's a possibility of 6 months in jail. Like I said, I've never seen this piece enforced. I don't know really of any situation where anybody's received any kind of jail time for denying access to a service animal, but I wanted to point it out, and when we open it up for discussion and questions, I'd like to hear what the law enforcement folks have to say if they've ever seen this put into practice. The final thing in the penal code that is important, and this relates a little bit more to the state law we talked about before, if you are a person that does not need a service animal, you are essentially claiming that you need a service animal, but you don't. You're committing fraud. You're fraudulently representing that you have a service animal, that you have an animal that's individually trained to assist you with a disability-related need, and you don't, then that is also a misdemeanor in California. One thing that Liz mentioned, there's some remedies through the Department of Justice for people who are denied access to their service animals. One thing that Fred will talk about, in California, under California law, both under the UNRU Act and the Disabled Persons Act, individuals have a private right of action to sue for damages. So essentially, you could file a complaint with either a state or federal entity like the Department of Justice, or if you have access to resources in terms of filing a case in court, you can seek damages, and under the Disabled Persons Act, as Fred will mention, you can get $1,000 per violation, and up to 3 times actual damages. And actual damages would be essentially anything that you were denied doing, or any changes you had to make as a result of the animal being denied access. Under the UNRU Act, which applies to any business establishment in California, so essentially any private business, you could get $4,000 per violation. For folks that do not have access to an attorney, and Fred's going to talk about this a bit as well, small claims court is a forum. There's actually provisions that allow people to enforce California disability rights laws in small claims court if they don't have an attorney and if they're under the small claims court maximum. The final thing I wanted to mention about enforcement is both the city attorney and the state attorney general, depending on whether it's a municipal action or a state action, have the authority to bring suit to remedy a violation of the Disabled Persons Act, including denials of access of service animals. Another thing I wanted to say about psychiatric service animals, we get a lot of calls from individuals who have a psychiatric disability, a mental illness, where that animal is actually individually trained to do something for them. It could be to remind them to take medication. It could be to notify them and take action when there's an early warning of a panic attack. Many of those individuals that we've talked to have been denied access because they do not have an obvious disability. I think we're very pleased that the department has issued new regulations, but I think there may be some confusion out there, especially in this state, about psychiatric service animals versus service animals that are trained for people with physical disabilities. If a person has a psychiatric disability, a mental illness, and the animal has been trained to do something for them, for their disability, as Liz mentioned, the animal is still covered as a service animal in California. If it's a comfort animal, if it's just for emotional support, if the animal does not do anything on behalf of that person, if the animal doesn't take any action, they're just there for comfort, under the law affecting business establishments in California, where it's a private business that's open to the public, that animal would likely not be covered. I also wanted to mention both the Fair Housing Act and the California Fair Employment Act, California Fair Employment and Housing Act as they apply to housing. in housing, comfort animals and emotional support animals, regardless of whether or not they perform any task. So it could be, somebody just needs the animal to help, maintain their, level of anxiety or depression, or to stop anxiety or depression throughout the day, but the animal doesn't actually do anything. We get a lot of cases involving housing. If it's a housing entity, an apartment complex, a condominium that's got a no pet rule, that entity can or should permit a comfort animal or an emotional support animal as a reasonable accommodation. We get tons of questions about that. I realize most of you are probably not operating housing entities, but I wanted to make that distinction because the law does allow, as an accommodation, somebody to have an emotional support animal in housing. I wanted to talk about some of the examples we've seen. The most typical call that I get is somebody that does not have an obvious disability. It's not a, quote, seeing eye dog. It's not a guide dog for the blind. And oftentimes I get a call where it's a restaurant owner or a small business owner, and both the party with the disability and the restaurant owner are in the room, and the restaurant owner is saying that we can't admit this dog. I don't think it's a guide dog. So I wanted to reiterate, if that happens, the restaurant owner or business owner can ask if there's a disability-related need for the animal, and also what the animal is trained to do. If the person provides an answer to those two questions, at that point the animal should be admitted into the public accommodation. We've had to mediate some of these situations. We don't often enter into litigation. We have shied away from litigating against small business. But in certain situations where it's a large public accommodation, we have litigated and sought both damages and attorney's fees where service animals have been denied. One example is we recently settled a couple cases in Southern California against Kaiser Permanente. They had a fairly significant no pets rules in certain areas of their facilities that were open to members of the public that did not have service animals, and we've worked out a settlement agreement with them so that service animals are permitted in the same places that Liz described, essentially if there's no risk involving something from the Center for Disease Control. So I wanted to point that out. We definitely do shy away from litigation when it comes to the day-to-day calls. We often provide technical assistance to people who are seeking to have their service animals enter private businesses, and we have mediated some situations before. But in the event a public accommodation does deny access, there is a remedy for litigation, whether it's through us, a private attorney, or the person suing in small claims court. So I wanted to turn it over to Fred to see if he wanted to add stuff about additional requirements under state law.
Only a couple of but never that food and agriculture alone require county to provide animal service animals. It's not required for a person with a disability being the service animal. However, if there is a service dog in training by a licensed trainer, that dog must be certified in order to for the trainer to be able to bring it in to a public accommodation or a public entity, and that name more within the disabled Persons Act. And never life a provision for a person with a disability disabled person had $1,000 for every incident. But I was the civil rights position for all protecting rights. People everywhere, but we $4,000 for instance. And that is addition to what we call injunctive relief, which is that they will be required to allow the door in. Finally, the other remedy that the state law allows for attorney's fees. So in the somewhat rare instance that a case needs to be filed in court, then the requirement the person will be entitled to attorney's fees, which unfortunately can be pretty high for even small litigation. And if somebody can't find an attorney because the file a lawsuit, they can file their own lawsuit in small claims court for $7,500 or less. The other option a person has is to file a complaint under the State's Department of Fair Employment and Housing. Yes, even though it's a public accommodation or public entity, the person would file a complaint with the Department of Fair Employment and Housing because they are the entity that enforces California's anti-discrimination statutes. In addition to the example that Stewart gave, we've also just completed a case involving a homeless shelter that had a policy of no animals, even service animals. We both in the manual and they ended up changing the policy to no animals at all, but we do allow service animals as a service dogs as a reasonable accommodation. I look forward to the question.
Good. Thank you, one and all. Let's see. We're actually ahead of schedule, so if we'd like to get question and answers.
Steve Stone, CHP at the Capitol. One of the problems that we're encountering are people showing up with generally small dogs claiming companion or comfort animals. What, I guess, what do you want to say, what regulations apply? Right now, if they say companion dog, we treat it as a service dog, we allow them in, but quite frankly, there's been some people that they're treated more like pets than a service dog. So what rights do we have? Or the companion dog, I think, is a bigger issue for us than a service dog, if I'm using terms correctly.
Yeah, I'm sorry, I'm hard of hearing. Where are you from?
CHP Capitol, State Capitol.
Okay. Until March 15th, companion or emotional support dogs are considered service animals. After March 15th, 3 weeks from now, they're not. Remember the definition of a service animal is a dog that's been individually trained to do work or perform tasks for the benefit of an individual with a disability, including a psychiatric disability, an intellectual or mental disability, in addition to a physical or sensory disability. However, our regulation is very explicit that comfort dogs and emotional support dogs, companionship dogs, therapeutic dogs are not considered service animals because providing companionship is not a task. It's not like alerting someone with a psychiatric disability that they have to take their medication or removing them, alerting them when they're doing damage to themselves or in a dangerous situation and where they're in an high anxiety situation. That's a task. So you can eliminate, exclude those dogs. If you ask, and you can ask, the two permissible inquiries are, one, is this dog necessary, required for a disability, and two, what tasks or work has the dog been trained to perform? And if the individual says it's a comfort or emotional support dog or something like that, you can exclude them. And if you do, and they file a complaint with us anyway, what I would do if I were you is I would just document, on what day, April 10th, someone came in and they claimed they had a comfort dog and I didn't let them in case they file a complaint with us, you have documentation of what you said and that you were felt based on what they told you that you were justified. Does that answer your question?
Yes. For me, my partner over here has a couple questions. So
sure.
I have a follow-up question for that. In what situations is that happening, and in kind of what circumstances?
One is when they recently had the spade and neuter law that was up at the Capitol. We had a lot of people show up with their dogs. They claimed that they were companion dogs, so we let them in. Recently, we've had a lot of healthcare hearings going on, and we've had a lot of people show up in their wheelchairs with the little miniature type of dogs. We've had tourists come in the Capitol with little chihuahuas in their purse. And that's what's kind of confusing. We had a gentleman the other day that entered the Capitol with a Labrador, probably about a year old, on a retractable leash, and couple, and probably retirees. Oh, it's our companion dog. And that to me is kind of in my opinion, I think they were using the system to their advantage, and we quite frankly didn't know what our rights were as far as asking, what services the dog provides, this type of stuff.
But I would reiterate what Liz said about the questions you can ask. If you ask them, what the animal is trained to do and they can't tell you, then it's probably just a companion animal. But if they do tell you something, if they say that it's trained to do X, Y, or Z, then that would be the difference.
If it was an elderly person and it was kind of obvious to you that they had difficulty walking or with balance and they were using a dog, and they say the dog helps me with balance, that our regulation explicitly says that's allowed. A companion dog, if they say it's a companion dog,
Companion, or excuse me.
that's not allowed.
Yeah, companion, we get companion or comfort dog.
No, after March 15th, those aren't allowed. Now, I want to reemphasize one thing I might not have underscored. And a miniature horse is not in the definition of a service animal. A service animal is limited to a dog. The miniature horse provision is in the reasonable modification of policies section of the regulation. So no one can come in with a miniature horse saying that's it's in the definition of a service animal, because it's not, but an individual who has a miniature horse and needs it for a disability-related reason, and it performs tasks or does work related to that individual's, directly related to that individual's disability, is allowed if it's under control, it's housebroken, and it as I mentioned, the other factors around legitimate safety concerns or type, size, and weight. Other questions?
Yeah, this is for the law enforcement. My name is Mike Sullivan.
Hi.
I was the ADA coordinator for San Francisco Police Department. I did this for 17 years. We had a lot of citations issued on service animal calls. Another thing, and it kind of goes for the CHP too, and this is unique, I want to stress this, only to law enforcement officers. When someone is falsely representing, it's a misdemeanor, therefore it's a crime. The elements of a crime, one of the elements of the service animal section in California is that a disabled person. If there's probable cause to believe, a police officer can ask beyond that because you're investigating a crime. Therefore, you can ask specifically about the definition because it's an element in order to cite. One of the things that occurred in San Francisco under the previous DA, I don't know what the new DA is going to do, citations were issued to businesses for not allowing someone with a service animal or denying access. It was referred to community boards. The CHP officers will understand this. On a second offense under California law, you can no longer issue a citation because it becomes a continuing offense. Then there's an arrest. Most all of these cases, in all the cases, we required an incident report to be written. Pretty much everyone went to community boards or they took it to civil small claims court. But the issue of, if you, as a law enforcement officer in California, that issue of an element of the crime, you can ask, what is your disability, because you're conducting an investigation. Again, you don't want to broadcast to anybody standing apart, take the person aside. Another thing to be careful of is under Title II, modification of policy, where a local jurisdiction may allow companion animals. I'm not a lawyer. I would say in that case, it's not enforceable under the misdemeanor section because it's not specifically identified. And just one other thing, that same section also includes mobility devices. So if someone's being denied access because they're using a wheelchair or a walker or other thing, the same law applies. I don't think that's very well known.
I wanted to clarify that piece. I'm glad you brought up the investigation piece. The only thing I'd want to clarify is that that would apply to the law enforcement officer doing the investigation, but not the business owner.
Only the law enforcement, absolutely only the law enforcement officer. And again, when I trained our officers, the idea was take the person with the disability aside so no one is eavesdropping or the business owner. Another thing to watch out for, we brushed up against this several years ago, just before I retired, is also be aware of potential for hate crimes, that this may be an underlying subtle way of committing a hate crime. It's really important to pay attention to what the person who is denying access is actually saying about the person with the disability.
I have a bit of a follow-up question to that. If a local jurisdiction has an ordinance that allows for an emotional support or companion dog, would that trump the ADA in the service animal definition, and would a public accommodation have to allow for that dog to enter the business?
Well, Stuart mentioned the preemption clause, which is that the ADA is the minimum, the floor, and if any other state or local law gives more protection to an individual with a disability, then that has to be followed. So the answer is yes.
And just to follow up on that, it wouldn't be enforcement of the ADA then, it would be enforcement of that state or local law,
Right.
whatever it is, so that when people come to us saying, well, can you enforce the ADA about this particular city's companion animal code, we can't, but we can enforce that particular code.
Yeah, we would have nothing to do with that because that's the the code. It's not a federal law, as Stuart said. It's not part of the ADA. Does that make sense?
Yeah, I'm just trying to make sure that for those business entities that are either on the webcast today or in the audience, that let's say there's a city or a county that does allow for that it's clear to them that they need to also check with their local jurisdiction so they know they're not violating any local jurisdiction access laws.
And each county should have an ADA coordinator that should also be enforcing state and local disability rights laws, and that person would be the best source of information about whether or not there is one of those state or local laws in your local entity. We've seen several. We've seen some that have them and some that don't, so you really have to check with your ADA coordinator.
Yeah, my name's Dan Kaiser. I'm with the California Council of the Blind, and I'm a guide dog user. And my question goes to the issue of psychological dogs, and even broader issue would be socialization and the confusion around the lack of socialization in a lot of these. I've seen it in service animals. I've actually seen it in bomb dogs at the Capitol. And federal bomb dogs are particularly unruly when it comes to socialization. But I've seen a lot of service animals that give the impression, because of their lack of social behavior, that they're not trained in maybe the tasks that they're able to do. Does the law address socialization behaviors at all?
No.
I was afraid of that.
The law addresses, as I said, the ADA is a civil rights law, so you have to think of it in that context. So individuals with disabilities have rights, which in many situations are limited, and covered entities, whether they're a public accommodation, a business, or a state or local government entity, have responsibilities. So, the limitation on the right to bring a service animal into a facility or a program is that the animal is under control. I should say it differently. I should say that it's not out of control, so that the handler maintains control. But I don't think the word socialization appears in our guidance at all.
If there's evidence that the animal is a direct threat, essentially a threat to the health or safety of others, then that could be a reason. That essentially doesn't allow the person to bring the animal. If their service animal presents a direct threat, then they could be barred from entering a public accommodation. But I wanted to make clear that that's a case-by-case analysis. So you'd have to know something about the animal. There'd have to be some sort of indication that the animal itself was a danger or a direct threat. It can't be based on some sort of generalized fear.
Yeah, I think any dog that's out of control, if you're not out of control, I don't know if you'd agree. I can't see how you could make an objective, factual case that you're a direct threat.
I believe it was. In the case I mentioned previously, that family been into aggressive. You can't try to get the dog to act aggressively to see if it's trained or not. Unless you can see that the dog is out of control or you have other evidence that the dog is a threat, you have to allow it.
And I just wanted to add to that. If the animal is in your business as a public accommodation, and you've asked essentially what the animal is trained to do, the next step, essentially asking for a demonstration of what that animal can do, is not allowed.
Right.
And there are several situations where it wouldn't be possible to do that. If the animal is only trained to act, in the event something, if the person is at the point of having a panic attack. Well, if they're not at the point of having a panic attack, the animal's going to do nothing. And
seizure.
Or a seizure, exactly. So it's really just the inquiry itself that can be made, but not asking for some sort of an action. So I don't know if that gets to the question of socialization, but I don't think there's anything that requires an animal to be socialized in any way unless they're out of the handler's control or they're a direct threat.
Okay. Ed Bertola, CHP. California has some budget issues that, people can exercise their rights, and the Capitol is a very popular venue to do that. We get large groups generally, and if there's ever an incident where someone is detained or a handler detained or even a custodial arrest, what's expected in regards to the service animal or that situation? Because it's come close quite a few times, and I kind of like to know a good answer, so if it ever does happen, we know exactly what to do.
Okay, so you need to educate me. In a custodial arrest, does that mean you're taking the individual?
Correct. If we're detaining somebody, it could just be that we need to do a little more follow-up, that we're investigating whether or not a crime has been committed.
Yeah.
If someone is under custodial arrest, they're under arrest. We're going through the process. There's generally handcuffs if possible, and they're probably on their way to county jail.
I'd want to double check my answer, but my gut answer is that you'd have to allow them, as long as they're maintaining control of the dog, to accompany the individual.
Okay, and again,
I would, and this is something we'd probably have to check on as well, but I'll give you a different scenario and let you see how it plays out that might answer some of the questions. In a situation where, say, a service animal is denied and something negative happens to the individual as a result, and it's a public entity, sheriff's department, county jail, that kind of thing, we have seen cases where the denial has been grounds for a claim. And obviously, there's some security issues and the things that we can't address, in this conversation. So, and security in the cases we've had cases with sheriff's departments and that kind of thing. Security is a factor, so that's always something that comes into play, and I couldn't answer it. But if there's absent some kind of direct threat or some security issue, if the animal is denied, then that could give grounds for a later claim.
So, because I think generally in my mind, where there's not a lot of clarity, we tend to tread very lightly, and because we want to keep everybody protected, and that's fine. Just in regards to if there was a sit-in on a street or some type of civil disobedience, and I just want to make sure I'm understanding, and if there's a way to transport the service animal with the handler, just to go ahead and do that?
Yes.
Okay.
Thank you. Yeah, I'm Roger Richter with the California Hospital Association, and we advertised today's program to our hospitals and are very appreciative of you putting this on. It's very helpful. But one of the main questions we got in about this whole issue, and you mentioned earlier hospital, litigation, the CDC guidelines need to be followed. But what guidelines or advice would you have for hospitals that treat, especially children's hospitals or hospitals with children's units that treat children that have high sensitivities, allergies, and someone comes in with a service animal?
Well, I think you need to take, do you do intake on admission of a patient as to what allergies they have?
Well, this could be, the answer is yes, but this could be, for example, in a waiting room before, the patient is seen.
Okay. The law requires reasonable modifications in policies. Let's just say hypothetically, I'm a parent and I have a child who's allergic to dogs. And I have, vision and I can see what's going on in the waiting room. And a dog comes in with an individual with a disability. I would move my child to the opposite side of the room or ask to sit in I think you would have to take reasonable steps once that parent tells you that they have a child who's allergic to a dog to allow them to sit somewhere else. You can't deny the individual with a disability. That situation is, you have to handle it in a reasonable way. And if there can be another room where either the individual with the dog or the individual that has the allergy can sit, it's a lot of common sense. Does that make sense? You can't per se exclude individuals with service animals because a patient who may be allergic to a child may be allergic to dogs may be a patient at your hospital. There has to be a practical way to work it out. That's my answer. I don't know what California law would say.
I agree with that. I will only add that is not only limited to hospitals, but using my case as an example, a homeless shelter. They argue the same question because the one room will be people, but you need to find a way to accommodate both disabilities.
That's the other thing I was going to mention. The person with the chemical or allergy sensitivity may have a disability as well. And so you may be balancing, on a kind of a practical level, that person's disability, that person's right of access versus the person with the service animal. And it is, I agree with Liz, on a case-by-case basis, look at it practically. How is the place set up? Where can one person be served? Where can the other person be served? But really do it on an individual level.
So I'll give you an example, and this is a real, in my office, two of the supervising deputies, one of them is legally blind and uses a service animal. One has a severe allergy to dogs. And they have management meetings, and they pair off. Sometimes the deputy with the service animal goes and sits in person. and the one with the allergy calls in from the, her office into the conference room, and then they switch weeks. It's just a way you have to work it out on a practical basis.
I'm Joy Van Kuren with Turning Point Community Programs, and this hearing actually came at a very propitious time because I have a situation I don't know what to do with. You guys touched briefly on trainers of service dogs, and as an employer, are you obligated to allow an employee without a disability who is engaged in the training of service dogs to train that dog while at work on your premises?
Okay, the ADA only covers individuals, so is it the trainer, are you saying, is a non-disabled person?
That's correct.
The ADA only covers individuals with disabilities.
Excellent.
Or individuals who are associated with people with disabilities. I would say if the trainer comes with the individual with a disability, that's one situation. And I don't know if we've had any cases of trainers who've come without individuals with disabilities. Have you?
Is it the public space of your entity that the person's going to, or are they an employee and they're just doing this on their job time?
They're just an employee.
And it's not where you'd serve the public?
In this particular instance, it's in a residential setting for crisis, for psychiatric patients in crisis. She has other job duties which kind of preclude being able to actively train the animal, and there's not a disability involved. There's no person with a disability involved.
So the training or the trainer rule applies to like business establishments and public accommodations. So a trainer could go into a restaurant with the service animal.
Right.
If your program was open, I know a little bit about Turning Point. If it's in the place where you serve the public, you might be considered a public accommodation, and somebody could come in with an animal in training, as long as they would have to be identified as an animal.
If it was in one of our office locales with outpatients, then there wouldn't be an issue here, but this is a residential setting that is not open to the public.
So in that case, I mean, I without knowing all the facts about the entity, I'm not able to tell you one way or the other. The only thing I can say is that the training rule in terms of business establishments and public accommodations might not apply there.
Okay, thank
you.
The
ADA doesn't cover private residences.
Stuart, maybe you can answer this. I know in 54.1, I believe, of the Civil Code, it mentions that if you are a licensed guide dog instructor, then you have the same public accommodation access as someone who has a disability. Is this what you're talking about, or you're expanding that beyond just licensed guide dog instructors in California to any trainer of a service animal?
No, I'm specifically referring to those who are licensed to train under 54.1 under the statute.
Okay.
So that's one of the reasons so the identification requirement can be applied to trainers, because they'd have to show that they're a licensed trainer that is essentially licensed under the statute. If it was just a person with a disability, you couldn't ask for that same identification.
Thank you.
Tom Scott. I'm on the Guide Dog Board. And maybe I'll sort of broach the issue that I think a lot of people, one, are attending or listening to this. I mean, no one likes to get sued. The state had 1.2 million lawsuits last year, just civil lawsuits. The state of California, I mean, I've heard statistics that only 2% of this state is ADA compliant. And that's usually a statistic that's thrown around a lot of times during hearings and various things. Add in the whole issue of service animals and the constant changing of ADA. This state certainly has been experiencing a rash of ADA lawsuits, which I'm sure most people in this room are aware of. The concern that I have is, we put in these laws, we add in regulations, we revise regulations, and somehow Bob Smith and his wife, who own that little store on the corner, are supposed to somehow stay on top of this moving target. And it's extremely tough. And I think one of the reasons why we're only 2% compliant is that it's just such a hard thing to stay on top of. And the concern, just listening here, you have the feds who say you can file a complaint, and then, private right of actions at the state level, and just the myriad of legal frustrations or concerns that business people have in trying to make sure they're doing the right thing. And I mean, do you have any suggestions? Because I would hope even your organization or the feds want to avoid litigation at all possible costs. That isn't to say it's not going to happen and will happen, but are there suggestions to the business community beyond going to a website and trying to figure out how you're compliant with the ADA, in addition to service animals and all those things?
Can I speak? One of our mandates under the ADA, the law itself specifically requires technical assistance on all issues, not only service animals. And we have, I mentioned our information line, and that takes calls from not only businesses and state and local government entities as well as people with disabilities. And we have a very large technical assistance unit. And we write new documents all the time. I'm in the process of writing a small business guidance that's intended for the small business that you referred to, the mom and pop on the corner. And we'll be putting more guidance up for the layperson. We try. It's my biggest challenge as an attorney is writing for the layperson, not writing legalese. So we view that as a very high priority, and not only writing it, but publicizing it. Not only just putting it on our website, but doing outreach to making sure that people know about it. And if people have suggestions about other things we can do with respect, my coming here and speaking today is a form of our outreach under our technical assistance program. If other people have ideas of what we can do, we are very open to hearing them.
And just to kind of reiterate that from a state level with our nonprofit, we do not have the resources to be litigating all over the state. Most of our work is technical assistance, counsel and advice, fielding phone calls, that kind of thing. We do provide technical assistance in the sense that we often end up, I wouldn't call it mediation per se, but we often end up working things out with small businesses and people with disabilities. I mean, we just don't have the resources to be suing small businesses unless there's something really egregious going on. So I would just, would encourage, you could actually, if a person comes into an entity where you've got a public accommodation, I would encourage them you could give them our number, you could have the person with the disability call us. Chances are we're going to push to work something out as opposed to litigate it. If you follow, the rules that Liz has described and essentially are parallel in California are pretty straightforward. There's essentially what you can inquire about, what the animal is trained to do. If you can take that away to your business communities and that kind of thing and apply it, then it's going to be a lot easier. In terms of the other kind of wave of ADA and state law litigation about physical access and that kind of thing, it's a different picture. California has actually changed its law in terms of state law claims for physical access. So there's this now we're kind of a required discussion, almost like a mediation period, where the business who is receiving the complaint has a chance to cure and has a chance to contact somebody who's been essentially approved for access. So that there's been kind of a balancing approach at the state level on that end. But in terms of service animals, I would just encourage folks to call and to work things out. I mean, I could speak honestly that of the, the thousands of calls we get per year, only 2 or 3 of them in our office at least get litigated. And so, we just don't have, we have a small office. We don't have the chance to litigate every case that comes in. It's got to be really egregious for a service animal case to go to court.
All right, Ed Bertola, CHP, with a follow-up question from before. We talked about earlier if someone is detained or arrested, what's expected. Just as follow-up, if the service animal cannot be transported, I know we have 3 different options. If someone has property, we can take it to our office and book it as property. If someone has minor children, we will usually stand by and wait for someone to take custody of the children. And also we deal with other animals that are not service animals. We will call the county services to come pick up the animal. Is there anything that we need to do that's specialized if it's a service animal as opposed to a regular animal?
I might actually defer that question to one of the guide dog board folks or somebody who's more familiar with transport and care of service animals.
Yeah, this is an issue that actually came up with one of the schools recently. We had one of the former graduates had passed away. Sure. Better? Okay. This is actually a situation that had come up several weeks ago where one of the graduates of one of the guide dog schools had passed away, and it became a matter of what to do with the animal when the police department showed up. What I understand the correct procedure to be, and we're currently in the process of reviewing this, is that the police department would notify the animal care and control, who would notify the guide dog school. This is guide dogs in particular, but and then the guide dog school would come and take possession of the animal, and then they would figure out what would be done with the rest of its career. But I think the initial answer to your question is that the law enforcement should contact the animal care and control, advise them that it is a guide dog, and the dog should be returned to the...
But if you're arresting someone, it's a 20-year-old with a service animal, and they lived with their parents, and they tell you that, they'd ask you to call their parents to take the dog, that would be the reasonable thing to do. Or a spouse, or,
Thanks. Okay, I'll try to talk low. Dan Kaiser again. I was having lunch, my wife and I were having lunch in a local Japanese restaurant, and our guides were with us, and we called a taxi. And we waited, I think, 3 hours before the taxi, in fact, no taxi showed up. And we kept calling the dispatcher, and the dispatcher kept saying, "We're looking for somebody." What it turned out was that the cab drivers kept going by because that company has a rule that they say you have to let them know when you call up that you have a guide dog. So we thought, maybe that's going to expedite things and we'll get our cab quicker. So we let them know, and it turned out all the cab drivers didn't want to pick us up. And so I took them to small claims court, and I lost. And it's very frustrating because, I'm not a sue-happy person, and, you try to do what's right. Fortunately, that company has gotten a lot better in the last couple of years because the city of Sacramento started scrutinizing that company. So thank goodness for that. Anyway, I'm just wondering why I lost because, it was clear that the dispatcher, they could have taken the dispatcher logs, looked at the logs. The judge could have, asked to have the dispatch logs read back. But I'm just amazed that I lost. And I have a feeling if I went to court again, I would lose again. So it doesn't seem like there's any real protection out there.
well, taxis, as you know, are covered by the ADA, and I think I have a vision impairment, and I, frankly, at night, I always fold up my cane when I'm getting a cab. And it's worse for my friends who use guide dogs and other service animals. And the only way that we found in the legal services community has found to look at this issue is to do testing. And there's a legal services group in Washington and D.C. that they videotaped people who were blind with their guide dogs with non-disabled people, separate from non-disabled people on the same corner or on the corner, across the street, to see who the cab would pick up. And to a person, the cab never picked up the blind person with a dog. And they have it all on videotape. But the difficulty in doing this kind of enforcement is that in most places, I don't know about Sacramento, but in a lot of cities, there are very small cab companies or there are individuals who, get a cab. It's not like New York City or other, large cities where it's yellow cab and that's it. So it's very hard to do the enforcement, and factually it's very hard to prove that X cab driver denied access to Y blind person. How are you going to prove it? Except if you had it on videotape. And that's very expensive and difficult to do.
Dan, have you been keeping a log of when you've been calling and which cab companies you're using?
I have not had any problem now for the last 2 years, so it's knock on wood. Like I say, Sacramento's been scrutinizing the cabs, and actually, I recommend Red Top Cab in Washington D.C. They're very good.
Great.
Yeah.
I'm not supposed to do enforcement. I'm endorsement. But now the other point I want to make is what you said, that they required, the cab company required to be notified that the individual had a guide dog?
I recommend that as a practice. I don't think
that's illegal. That's totally a violation.
Wow. Okay.
Dan, if you've got ongoing problems, please let me know. You can give me a call. I know you already have my number, but give the Guide Dog Board a call. My email is also on guidedogboard.ca.gov because that's an issue. I'd personally love to.
Yeah, well, like I say, the city's really gotten a lot better because the city's monitoring the cab companies because they have new requirements for cab companies. They're trying to get rid of the 2 to 5 cabs that drive around and uninsured cabs and things like that. So they've really cracked down in Sacramento. So, that company, I don't really have any complaints, but I'll let you know if I do.
Fantastic. Thank you. I appreciate that. Because if it's happening to you, it's happening to other people, and we'll put an end to that.
We have one more question before we go to break, and it's about 10:45.
So, Mike Sullivan again. I just wanted to go back to your question on the arrest issue. It's kind of a two-prong part to it. Is one, the actual arrest by the officers or the CHP at the scene. The animal can be transported with the person. Now, if you're going to a local jail with the holding facility at a district station, your agency should have a policy about how to deal with that. If you're anticipating like a demonstration, which I'm sure you get at the Capitol all the time, it would be good to work out ahead of time with animal control that there may be potential for an arrest. The second part of this is the custodial issue, the correctional issue. What I would suggest is if you make the arrest at the scene and you decide you're going to actually take the person to custodial arrest, go to the county jail, that you have a policy to notify the watch commander at the county jail that you're coming with a person with a service animal, because then it becomes an accommodation issue for them in their housing, what they're going to do with that person, and also the local sheriffs have their greater discretion in what they can do with people that are in custody. But I've never heard of a problem transporting a service animal. But again, you can work that out ahead of time. We had an arrangement with animal control, and it goes back to what Liz said. If the person wants the guide dogs to come and get the dog or some other agency, that's fine. But it still is an accommodation issue for that person with a disability from that point on for both the police agency and the correctional agency.
Very good. So we are currently on schedule to take a 15-minute break. So why don't we do that now, and we'll be back here. Thank you. Okay, thank you. And we're back from our break, and I'd like to continue with the Q&A session. So if there are any more questions.
Okay, I have some questions. If an aggressive-looking dog comes into a business and customers are scared of the dog, is this enough justification to ask the individual to leave the dog outside the business?
No. And the reason, this is not to cast negative aspersions on you and the way you drafted the question, but it's got to be the exclusion, as I said earlier, has to be based on the dog's behavior, and just because the dog looks aggressive doesn't mean that the dog is aggressive. And the ADA is very clear that customer preference is not a justification for excluding anyone. So if the dog was out of control, was not housebroken, the handler could not regain control, or the dog was a direct threat, a significant risk to the health or safety of others that couldn't be reduced by reasonable modifications of policies, those are the only rationales for exclusion. But just because a dog looks to be aggressive is not a reason for excluding them. Barking, it depends on the situation. Is it a noisy restaurant? I mean, prolonged barking, that's inappropriate. Barking in a movie theater and the handler can't get control, then the dog is out of control, given the situation. Or a theater, an opera house, some kind of similar performance, where everything is quiet. If it's an amusement park where everything is noisy and you can't even barely hear the dog barking because there are kids screaming, that's a different situation. Does that make sense?
And we've had calls about professional sporting events where the dog is barking, but there's essentially so much noise around that only one or two people are essentially disturbed by the dog barking, and there could be some accommodations where those people are moved to other seats. Maybe they're moved to better seats.
I have a question. In the case of a self-trained dog, person with a disability who's makes the claim that you're training the dog themselves, do they have access with the dog when it's not yet trained? In other words, it's not doing a task to mitigate any aspect of a disability, but their claim is that it will someday and it's in training now.
Alone if they get the tag from the county that says that it is a service dog in training.
That's California law? Well, the ADR regulation says is trained. That, when you look at the specific, how the definition is worded, it says is trained. So I don't know how we would look at that.
What if somebody called us with that question? We'd actually ask them to go to their county and see how the dogs are identified as animals in training.
In that case, I've got a follow-up. That tag in California is problematic because it varies by county. Some counties don't even issue the tag. Schools, I represent Canine Companions for Independent. Our school issues the tag to our California graduates. Unfortunately, that tag can mislead the public more than provide accurate guidance because people misrepresent their dogs as real service dogs because there's no test, and so they get the tag. Other people do not get the tag, and so a merchant will deny them on that basis. The tag is problematic.
I would agree with you that we've seen several situations where it's problematic. I mean, the difficulty is the tags at the end of the day, if it's not an animal in training, if it's just a service animal, it's not required. And so there is the fact that so many counties have this tag identification and registration process, and the businesses know about it, essentially because they've talked to the county, they've looked on the website. There's an instinct there to want to require the tag. So I have the same thoughts. The other side of it is we have so many people that call us that want to have some sort of preemptive, almost like a shield, to prevent them from being denied access to their service animal in the business, and that's it's kind of a balancing. The other thing I would encourage folks to do is to talk to a group like yourself, because that's even though it's not required for a service animal, the issue of service animals in training is it's a little bit vague, and I always get as much protection as you can, and so we would if they can, they should talk to a licensed entity.
Okay, I'll ask the second question. If a dog relieves in my store, I'm a store owner in this scenario, can I ask the individual to remove the dog?
The guidance that accompanies our regulation says, as I think I mentioned, the dog has to be trained to retain waste absent illness or accident. So that's a factual question as to why the dog relieved himself. Whether he was sick, whether it was just an accident, or whether the dog wasn't housebroken.
Okay. When asking an individual what task the dog is trained to perform and the person responds mental support, is this enough justification to allow access into my business?
No. Because comfort or emotional support animals are not within the definition of service animals. That's not a task.
And for those individuals with disabilities or people that are going to talk to people with psychiatric disabilities out there, I mean, the question that these folks should be prepared to answer is what the animal is trained to do. I am concerned that some individuals with psychiatric disabilities are going to be excluded because there is a bit of a body of law about comfort and emotional support animals, and as Liz said, there's been some history of allowing comfort and emotional support animals, and so people that may have an animal that's trained to do a task for a psychiatric disability or a mental illness need to know that they're going to have to be able to supply the reason that they have the animal and what task the animal's trained to do, as opposed to just telling people it's a comfort or support animal. I think that's the fact that it's been allowed to exist in public accommodations before is going to be confusing for the actual person with the disability.
One follow-up that would be helpful for the person to ask is, has it been trained to do so? To help you.
Okay, next question. How can a member of the public or a business owner ascertain whether a service animal is legitimate? If an individual has doubts about the legitimacy of the dog, what is their recourse? For those that have legitimate service dogs, what recourse do they have for those that do not have a legitimate service dog, and I have this in parentheses, to prevent abuse of access laws by others.
Okay. The only individual who can ask the questions under the ADA, because the questions go to the issue of whether the dog can be excluded from either the state or local facility or program or the public accommodation, the private business. The only individual who can ask those questions are either a staff person of that entity, or the owner or the facility operator, not an individual of the public, a fellow customer. Because remember, the structure of the ADA gives rights to individuals with disabilities, and which are limited, and rights to obligations and responsibilities to businesses, which are also limited. But if one, I assume what you're getting at is one owner of a service animal has concerns about the legitimacy of another service animal, they don't have the right to ask that individual about the service animal, their service animal. Only a business owner or a staff person of a state or local government entity would.
Yeah, I agree with that completely. There's no right of another individual to make those kind of inquiries. I mean, in California, we've talked about this before, it's a misdemeanor to fraudulently misrepresent that you have a service animal. And in fact, with the county requirement with the tags, you've actually got to tell the county that you understand that there's this fraud rule and that could be a misdemeanor. So I mean that's one. I mean it's a remedy available to law enforcement. But I'm a little concerned about people in the public going out and policing on their own as to whether or not somebody has a service animal, because in many cases it's impossible to tell just by looking at the animal what task the animal is trained to do. And so I mean I think there's good reason why the business owner has a certain limited set of inquiries they can make, and it's not open to members of the public.
And just as a follow-up to that, I have received some inquiries from some of our guide dog users about quote-unquote service animals that may not in fact be service animals, that may pose a threat to their guide dog by distracting their guide dog while going from point A to point B, getting in the way of their transportation and their access. So I think that's why I wanted to make sure that for those that have that question, that, obviously we don't want people to police others in that way, but we certainly want to maintain the access and transportation rights of legitimate service animal owners such as guide dog users.
If the person is bringing a service animal into a public accommodation and that person's service animal is facing difficulties due to, another dog or anything else, that person should raise it with the public accommodation, and there could be some sort of practical working out of how that person could be provided access.
Okay, thanks. Question from the audience? Hold on one second.
Yeah, following up on what Antoinette was saying, I'm in the restaurant, the other person's quote-unquote service animal is unruly, therefore causing the distraction, which is usually the case. The dog is usually out of control, trying to leap at the dog, and so I think it's a control issue. So what would we do as guide dog users to try to get that handler to assert control?
You don't get the handler, you tell the waiter, the owner, or the manager of the restaurant to tell that to tell the handler. You don't do it. Okay. You ask the business, manager, waiter, whoever. You see the difference?
Yeah.
And that waiter could ask the out of control animal and their handler to leave.
Right.
I'm Becky Tolbert with the Office for Special Services, the Assistance Dog special allowance program, and we provide a monthly stipend to individuals who require the services of an assistance dog. Okay, and I kind of would like to explore a little bit the subject of alert dogs, if that's possible with you, and how that's covered under the ADA. And just a couple of questions, particularly seizure alert, dogs that alert to allergies, which is covered, dogs reminding individuals to take medication, those types of things. They are protected under the ADA. We ask questions because there have been instances where someone has reported that their dog is a seizure alert dog, but then they've only had one seizure in the last year, or different things like this come up, and have a responsibility to the taxpayer as well as individuals that truly require the need for a service dog. So can you help me maybe to understand how I can apply this a little bit better in what I do in processing these applications?
Yeah, let me make sure I understand this. So you're an agency that provides service animals to individuals?
No.
And you have eligibility criteria about who, given your limited resources?
Yes, we provide a stipend.
Okay. That's not an ADA issue.
Okay.
That's an eligibility criteria for your program.
Okay.
The ADA issue is once an individual has a dog, where they should be admitted, how they... Does that answer your question?
It does kind of, and I guess the reason why we're here today is to get a little bit more information so that we can understand a little bit more about the service dogs, because these issues come up.
Yeah, no, I understand, and I apologize if my answer seemed curt, but you can speak to California law, but it's not a civil rights issue. Well, it might be actually. If you're a state program and you say, we're going to have eligibility criteria where we're not going to give service animals to anyone who had a seizure, only had one seizure a year, you'd have to have objective medical evidence to back up that that was reasonable. Unless you limited your program to just providing guide dogs or dogs for children with autism.
Excuse me, I'm sorry. We don't provide dogs. We provide an allowance to care for the service dog. I'm sorry.
You provide what?
An allowance to
care for the dog?
To help a person with a disability care for their service dog.
Wow.
So
I've never heard of any state program that's so generous.
So we just want to be responsible in making our determinations.
Yeah.
And just a comment on our program is so simple. All we ask is that the dog provide a service and that the person have a disability and that service helps with that disability, that it's related, okay? And
you don't require medical documentation?
No, but we get it because people voluntarily send this to us, and we get the service dog tag paperwork. And then the doctor has prescribed a companion dog for this person, but then they have a service dog tag. So there's a lot of issues that we have, and we want to just make sure that we're making responsible decisions on these claims, and it's only with the service dog category. We also provide the stipend to individuals who use signal dogs to alert to sounds, hearing dogs, and guide dogs for the blind as well. So
I probably wasn't responsive to your question at all, right?
I'm
Why
sorry.
don't you give me your card and I'll talk to my colleagues and get back to you on the limiting it. And
The only thing I was going to say is that so it is. I agree with Liz. It's a different issue than the service dog rules and regulations. It's actually a stipend. a particular stipend going to a particular group of people with disabilities and whether or not there's discriminatory criteria for that stipend. And it's a kind of a factual case-by-case thing. I don't think it's ruled or governed by these service dog regulations. I have the same feeling that Liz does. But one thing that, that you should, if you're just looking at types of service animals and seizure or alert animals, it may make sense to do some research, talk to folks who have these kinds of animals, talk to the medical community, talk to the trainers and that kind of thing, to really kind of come up with an understanding of what those animals do. And I don't have that much experience personally with alert animals for seizures. We've had clients that have had them, and in that situation we've asked for medical documentation. We've gotten releases to speak to the doctors to really kind of understand what the animal does for that individual. But it is a case-by-case analysis. I think I would encourage you to do general research, your program and its stipend may not be bound by the limitations on inquiries. You're essentially giving money, for giving a monetary benefit as opposed to providing access to or from a public accommodation. So you may have more room in terms of what you require for eligibility. You may be able to require eligibility criteria, and it's going to depend on other kinds of rules governing discrimination. But on a general level, I would encourage you just to do research, maybe talk to some of the folks on the guide dog board. If somebody came into my office and said, I'm trying to apply for a stipend and I have this alert animal, what should I do? The first thing I would do is I'd work with them on getting medical documentation, getting a clinician to tell exactly the steps the dog takes when they have a seizure and how to get it documented.
Okay, thank you. I have done some research. It seems like there's different opinions on both sides. There isn't really any scientific evidence that dogs can alert to any medical condition. However, we do know dogs are very intuitive and have a lot of, they're capable of doing many great things. So we just want to be balanced in our approach, and we were looking to the ADA for some guidelines, maybe as a basis to help us with our own determinations and our own eligibility.
I'd be happy to look at this issue kind of in the same way Liz would, and I should give our 1-800 number to everybody anyway. It's 1-800-776-5746. And hopefully that information is on the contact information for the program. But I'd be happy to look more into the issue in more detail.
Yeah, so would I. So just come up before you leave.
Yeah, I think what she's really trying to get at is it's defined by I believe in your case, your program is defined within, I believe, probably the Welfare and Institution Code. And so your guidance is that particular part of the law where it would say service signal, and I haven't read that particular statute in about 3 years. It seemed to me it said something like service signal and guide dogs for the blind. And so if the definition of service animal has changed, then the state law automatically, I would think, would change to conform with the definition of service animal. And so, it seems like the state law would change in March. I mean, if the federal law got stronger, then something would have to change. And I don't know where it relates to the state law changing to conform to this in March either. So someone would have to answer that for me as well, because I don't know.
Just to clarify, the state law would be as strong in terms of protecting the person with a disability's rights as federal law. That's this kind of minimum or floor preemption rule. But I don't know in particular how it applies to this particular. I don't know the details of this particular statute in terms of how they give out or dole out these stipends and what the criteria is.
In the event that you believe you have encountered a case of abuse of a service animal right, what recourse does an individual have to respond? Is there a reporting process for this scenario?
Who's the you? If a business owner or a state or local government has the right to exclude an animal, a service dog, if they believe if they've asked the 2 questions and they feel they haven't gotten an appropriate response, but on the other hand, that individual could file a complaint with us, as I mentioned earlier. And that's why I mentioned if you do exclude an animal, you should document, keep on file a record of the date you did and what the circumstances were so that you can justify it if the individual ever files a complaint. But a member of the public, there's no reporting for a member of the public. The relationship, remember again, it's the ADA is a civil rights law. It's the issue is between the individual with a disability and the business or the state or local government entity.
I would just follow up. If the person can't answer the questions that the business is allowed to ask, then the business could exclude the animal. Other than that, I don't know of another remedy.
Okay. If service animal users are denied access, what is the, don't understand my own question. If service animal users are denied access, has the recourse for action changed under the new rules?
No.
Okay. Are there exemptions to accommodations for service animals? For example, what is the process for complaints regarding exemptions such as churches, bed and breakfasts, any other places that may be exempt from the public accommodation?
Okay, well, as you noted, religious entities such as a church, a synagogue, a mosque, in and of itself, that entity is exempt. It's not a public accommodation. So they don't have to follow any of the ADA's rules. If a daycare center, if the church operated a daycare center, that daycare center wouldn't, or homeless shelter or whatever the social service program was, because it's being operated by the religious entity, that would also be exempt and wouldn't have to follow the rules of the ADA. However, if a private daycare center or a private nonprofit social service entity, like a homeless shelter or whatever, clinic, leases from space in the church, that private entity that's not controlled by the religious entity, is covered by the ADA and has to follow the rules of the ADA because it's operating a place of public accommodation. The bed and breakfast example, bed and breakfasts that have 5 or more guest rooms where the proprietor resides on the premises are 5 or more guest rooms, they're covered. And I think they're excluded if I can't remember I think they're excluded if the proprietor resides on the premises.
Just to follow up, if a consumer has a question about a bed and breakfast, I actually don't know the rules surrounding bed and breakfast in California, and I don't know if it goes beyond the federal law in that sense. But I would encourage folks, if you have a call like that, or if one of your friends or someone using a service animal has an issue with a bed and breakfast and they're not sure about the state law, to give us a call and we'll research it.
Thank you. What is the liability of the business for violating the ADA in regards to access to service animal teams?
If the individual files a complaint with us, we can, as I noted earlier, we typically negotiate a settlement, which will require the business owner to establish a policy and publicize that policy in a prominent place on its premises as well as on its website, to do comprehensive staff training on an ongoing basis, especially for new employees. Sometimes it's appropriate we get compensatory damages for the individual, and in some circumstances, we get civil penalties that go to the U.S. Treasury. The individual under the ADA can also file a lawsuit in federal court, but they cannot get compensatory damages. Only the Department of Justice can. They could get injunctive relief requiring a policy, et cetera. And in California law?
In California, however, you can get damages up at least $4,000 per violation, or 3 times the actual damages.
The kind of per violation rule, the per violation rule in California is a little bit complicated, but in some cases, if a person, say the person goes to a public accommodation, every day, and they're denied access to their service animal every day, there is some case law where that person's allowed to claim that $4,000 for every day they go to that public accommodation. So it can certainly add up. You don't see it that much in the context of service animals, and it's you see it in terms of access violations, physical access, and that kind of thing. But it's possible, and in the cases where we've had against larger public accommodations like large healthcare providers, homeless shelters, and that kind of thing, we've sought both monetary damages and attorney's fees. So it's not something, like I said, we're not going to jump in and litigate. It's not necessarily our desired role at all times, but it's possible, and it sometimes does happen. In a particularly egregious case, that the public accommodation could be liable for significant damages and attorney's fees.
Lance Wolf would like to know what is the reasoning for not requiring all service guide dogs to be certified?
Well, one of the reasons, there's no national certification. And, tourism is a big business in most parts of the country, especially in California. And it would be administratively incredibly difficult, as well as it would be discriminatory to, in my personal view, to not allow a resident from another state to bring in their service dog if there was no certification process in their home state.
Even within this state, the actual certification, even though it's a state statute, is controlled by each county. So there's a chance it could vary county to county, and you wouldn't want to limit people's ability to engage in commerce or to visit other counties.
Who carries the liability if there is a dog bite from a service dog to a member of the public?
That's actually a tort issue, and it's not an ADA issue, so that would be covered under California law. And what would California?
None of us up here are personal injury or tort lawyers, so I've actually never had a case involving a dog bite by a service animal, at least where we would be seeking money, to compensate the person for the bite. So I would say it depends on California tort law, California personal injury law. The only thing that I would say is that California law, if a service animal creates some sort of damage to a public accommodation, I'm not necessarily saying a bite, but they destroy something or something like that, then the person who is handling the service animal, the owner of the service animal, could be responsible.
Can a city or county require a service dog apply for an identification tag?
No. Well, as I said earlier, you can't require a service animal to apply for a service animal identification tag. If you require all dogs to apply for a certain identification tag for another reason, that's not related to the fact that they're a service animal, but that requirement applies to all dogs. That's permissible. But to require a service animal to apply for a service animal identification tag, that is not permissible.
So then the Food and Ag Code would be in violation? Or
Food and Ag Code actually contains a specific section saying if any portion of this law, the statute, violates the ADA, then it's invalid. And so it's actually written in a very kind of narrow way to essentially parallel or combine or work in conjunction with the ADA. And that's one of the reasons the state has been very clear. And actually, people I've talked to at the state, people I've talked to about the Food and Ag Code, everyone is very clear this is an optional thing. Most of our clients use it as a preemptive measure, essentially that they're, they don't want to be barred. They want to have something to show. And we've talked about the pros and cons of the existence of this Food and Ag Code, but it does not in any way prevent somebody from exercising their rights under the ADA.
Miniature horse questions. What accommodations does a small restaurant need to provide a miniature horse? What constitutes a miniature horse?
Okay, as I mentioned earlier, typically miniature horses are between 70 and 100 pounds, and the Miniature Horse Foundation says the ones they use are about 26 inches high. They're typically no more than 34 inches high. And there are 4 factors that the restaurant would have to look at. One is the type, size, and weight of the horse and whether the particular accommodation can accommodate it. So, that would be a question of the size of the restaurant and where there's a space, whether there's a space for the miniature horse to be placed. The table, it depends on the factual situation, and the size of the specific horse. The horse, again, has to be, it cannot be out of control, and the handler has to maintain control, and it must be housebroken. And there has to be some analysis of whether having the specific miniature horse on the premises would compromise legitimate safety standards. So it would depend. But I think if I were a small business, I would think through those issues. I really don't think that there aren't a lot of people who use miniature horses. There are some. But if I were a small business, I'd think through this ahead of time and come up with a factual, when it would be permissible and when it wouldn't, given those factors. But just saying that a miniature horse is going to be excluded no matter what would be problematic from the ADA's perspective.
Okay, I have one last question. What are the limitations for access to miniature horses? Are ambulances and emergency rooms required to provide access to miniature horses?
Well, this applies, those factors that I just went through, the 4 factors apply. But you have to think about who's using it in that situation. Is the individual with a disability the patient in the ambulance? If so, the miniature horse, or the service animal, the dog for that matter, is not doing work or performing a task because the individual is lying prone in an ambulance. And, we talked about the transport issue, and the same would apply. And the same issue applies to an emergency room. Is the individual the patient, the individual with the disability the patient, and therefore the animal's not doing any work or performing any tasks? It all depends. There's not a yes or no answer to that.
I mean, I would apply the same rules that you'd apply to another service animal in the context of an ambulance. I would apply the same rules that you apply to another service animal. I guess miniature horses technically aren't service animals, but to the extent they're allowed, you know, what tasks the animal's performing. Just as a caveat, I've not had any cases involving miniature horses, and I would echo what Liz has said. I just don't think that's that common. Maybe because of the change in the regulations, we might see more miniature horses, but I've never seen one.
Public or on the internet?
No further questions.
All right, very good. Thank you very much all for coming. Thank you for your very fine questions to shed light on all of the new changes. I'd like to thank the Department of Consumer Affairs for providing us the webcam and the hearing room, and I'd like to thank the board for allowing me to be up here as the Master of Ceremonies. Thank you, one and all.